Of HM Inspector of Health and Safety versus Chevron North Sea Limited.
Lady Black will give the judgment of the court.
Chevron North Sea Limited operates an offshore installation in the North Sea. In April 2013, the installation was inspected by Her Majesty's Inspector of Health and Safety. The inspector formed the view that the stairways and stagings providing access to the helideck had been weakened by corrosion and become unsafe. A prohibition notice was therefore served on the company under Section 22 of the Health and Safety at Work Act 1974, restricting the use of the deck. Chevron North Sea Limited appealed against the prohibition notice to an employment tribunal under Section 24 of the Act. The company had the metalwork, which had concerned the inspector, removed from the installation for testing. One panel had been damaged during the inspection and couldn't reliably be tested, but the results showed that the rest of the metalwork met the relevant British standard in relation to its strength, and there was no risk of personnel being injured by falling through it. Chevron North Sea Limited wished to rely upon the test results as part of its appeal against the prohibition notice. The inspector argued that that was not permissible because, in an appeal under Section 24 of the Act, the tribunal must focus solely on the information that was, or reasonably ought to have been, available to him when he served the notice. The tribunal decided that it could have regard to the material that had become available after the time of the inspection and cancelled the prohibition notice in the light of the test results. On the inspector's appeal to the First Division of the Inner House in Scotland, the tribunal's decision was upheld. However, as the Court of Appeal in England and Wales had taken a different view of the proper approach to an appeal under Section 24 in a different case heard in 2015, the Inner House gave the inspector leave to appeal to this court. The issue for this court was, therefore, whether a tribunal determining an appeal under Section 24 of the Health and Safety at Work Act 1974 could have regard only to the evidence that was or should have been available to the inspector at the time of his inspection, or whether it could also take into consideration evidence that became available at a later stage. This court decides, in line with the tribunal and the Inner House, that later evidence can be taken into account. In so deciding, the court considers Section 24 in the context of the scheme of the 1974 Act, bearing in mind what an important tool a prohibition notice is in ensuring public safety, but also recognising the potential that such a notice has to harm the business upon which it's served. At the time that the inspector serves the notice, under Section 22 of the Act, what matters is his opinion of the situation. He has to be of the opinion that the activities in question, here activities in relation to the use of the helideck, involve a risk of serious personal injury. When it comes to an appeal under Section 24, however, the focus shifts to whether the risk in fact existed. And there can be no good reason to confine the tribunal which has to decide that question to the material available to the inspector, who may, of course, have had to act urgently and without the luxury of comprehensive information. This view of the Section 24 appeal process does not undermine the effectiveness of the prohibition notice, which, unless specifically suspended by the tribunal pending the determination of the appeal, remains in force until the tribunal has been able to make a fully informed determination as to whether it should or should not be modified or cancelled. Accordingly, as this court agrees with the Inner House, the appeal is dismissed.
The court will adjourn.